Everyone, my name's Anne Dugan. I'm one of the managing partners of Think People. You're all very welcome this morning. We are going to be looking at a number of issues related to the employment within the current pandemic. And we're going to be focusing on reduced working hours, changes to terms and conditions, the recent changes to the furlough scheme, and then moving on to redundancies. We've quite a lot of information to cover this morning, and you're certainly very welcome to put up questions on the chat box, and we will try and maybe have a look at those at the end of the session. But if that's not possible, what we're planning to do is to get out a Q&A document, and we hope that Q&A document will be out with you on Monday. We will also send the slides out after this morning's session, we'll work through it. I want to introduce you to my co-presenter this morning, which is Aisling Byrne. Aisling is a director with Cleaver, Fulton and Rankin Solicitors, and Aisling is going to kick off the session, and then I'm going to come in a little bit later in terms of the practicalities of managing redundancies in our current setting. So I will now pass to Aisling.
Morning everybody and happy Friday. I was saying to Anne when we were having a chat before we started, it's hard to know what day of the week it is, but at least it's Friday, so you're all very welcome this morning. No discussion about the workplace at the moment would be complete without a mention of furlough. I think in March I'd heard of the word, but I wasn't even sure what it meant, and I think we all know by now that it essentially means a leave of absence from the workplace. Traditionally used, I think, in the US as a term, but it now has been the lifeline that saved so many businesses. And I think a sigh of relief was breathed by many on the 12th of May when the scheme update was announced. There have been so many iterations of the scheme now, so many changes, but I think the announcement on the 12th of May was significant in that the scheme is going to continue until the end of October, not completely in its present format. So the current process whereby employers are reimbursed up to £2,500 will continue until the end of July, and then from the 1st of August the scheme is going to change. And I think that's in recognition of the fact that there was a lot of discussion about the fact that employees weren't permitted to do any work under the scheme. So from the 1st of August I think a certain level of work is going to be required, but the scheme contribution then from the government is going to change. We don't know exactly what the change is going to be, but the government has said that further details will be announced at the end of the month, so hopefully we should find that out pretty soon. So what are the key furlough points to bear in mind? Well, the minimum furlough period is 3 weeks. The other thing to think about is the fact that you need to keep records, and the records need to be kept for 5 years. You may have seen in the media reports about the furlough whistleblowing hotline, and I think as of yesterday there were 800 reports to that hotline, and I've heard anecdotally that there are quite a lot of employers who are furloughing employees but still requiring them to carry out some work, and that's a definite no-no under the scheme. It's pretty clear under the terms of the scheme that employees really can't carry out any work at all. They can't provide services to the employer, and the most really they can do is undertake training. So for example, if you're a professional services firm and your employees need to carry out continuing professional development, for example, it's perfectly legitimate for your employees and your staff to do that when they're on furlough. But anything more than that, you know, we've had a lot of queries from employers as to whether employees can dip in and dip out, and the answer is really no, because you risk HMRC coming after you after the event to seek reimbursement of the monies. Another question that we've had quite a lot has been in relation to holidays and whether you can require employees to take holidays during the furlough period, and the answer to that now very clearly is yes. You need to bear in mind that you need to follow the provisions under the working time regulations. So the rule of thumb is that whatever period of holiday you require employees to take, you need to give them at least twice as much notice. So if, for example, you're going to specify a week's leave in June, for 5 days, you need to give 10 days notice to your employees. But other than that, there shouldn't be any difficulty, particularly given that the scheme is now going to continue through June and into the end of July, when most people in Northern Ireland would really be taking some sort of holiday leave. Then I think it is legitimate to ask employees to take holidays, because what that does is it prevents a huge build-up and accrual of leaves that you're going to want to avoid when you're actually in a position to bring people back into the workplace. I suppose the only caveat to the leave point is the fact that the guidance states that employees need to be able to have proper rest and relaxation. So I don't know how an employee could argue that they're not having rest and relaxation during the furlough period, but that's just one thing to maybe bear in mind if you're going to specify a shutdown period. So we're all now turning our minds to how we actually get back to work. I know that some industries are continuing, and manufacturing and food, in particular food production, has continued, but a lot of us are really now all working from home, and the focus is turned to how we're actually going to get back into the workplace. There's a slight divergence between the position in England and Wales and Northern Ireland, and the NI executive has announced its 5-step plan that was released on the 12th of May. The difficulty really with it is that there's no set timetable at the moment, but I did see the announcement yesterday that garden centres and recycling centres are going to open on Monday. So there definitely seems to be a relaxation in the lockdown, and I suppose that's going to unfold over the coming weeks. I think the default position really, even in relation to the NI guidance, is that employees will still continue to work from home where possible. And if you're looking for information, I think the best place to start is the Public Health Agency website. Also, the Health and Safety Executive has some useful information. And then looking at the UK government position, they've released sector-specific guidance in relation to 8 categories of workplaces, from construction to shops. It's quite comprehensive. The guidance has sought input from the NI and Scottish executives. So the Northern Ireland executive has been feeding into this guidance, and so it is relevant when we get to the stage where we're going to be returning to work. And if you look at the office and contact centre guidance, for example, it's a 32-page guidance document, so there is a lot of useful information in that in relation to what you need to do to prepare to return to work. But really, when you look at it, the default position is that if people can continue to work from home, then really they should continue to do that. There's been a lot of talk about health and safety and how you manage that in the context of a return to work. As an employer, you have obligations under the health and safety legislation, the Health and Safety NI Order of 1978, but you also have a common law duty to protect the health and safety of your employees. And I think a key point that you'll see in the return to work guidance documents for each sector is the requirement to carry out a health and safety risk assessment. And a lot of employers and businesses are asking, well, where do we get this? But there is a useful template on the Health and Safety Executive website, and you can see how you go about that, and there is some guidance then within each sector specific document. The government is saying that once you produce the health and safety risk assessment, that really you should publish it. If you have less than 5 employees, you don't need to produce one in writing, but really every business should have a written risk assessment in relation to returning to work post-COVID, I think. And if you have more than 50 employees, you need to publish it on your website. But again, even with less than 50 employees, it's probably a good practice to publish it. And then consultation with employees before you even get back to work is key. That's also a requirement set out in the guidance. If you have an existing forum for health and safety representatives, then I suppose in bigger workplaces you would use that. If not, then you might have another representative forum for employees, and you can open the lines of communication, because clearly you're going to have to talk to employees about inducting them in relation to a return to work. I don't think any of us are going to return to a workplace that's the same. There's no businesses that haven't been impacted by this. And when you look across the sector-specific guidance, a common theme is the 2-metre distancing, for example. So no matter what type of work you're engaged in, there are going to be some changes. There are going to be a requirement for employers to increase their cleaning protocols, their hygiene, hand sanitizer, PPE were required, screens, and in an office environment, for example, not having employees face-to-face. The guidance talks about phased return to work, staggered work start times and finish times. So there's a lot for employers to consider. And health and safety, I've seen a lot of talk in the media, particularly in relation to people having COVID or believing that they caught it in the workplace. And one thing just to bear in mind as an employer is that, you know, there are provisions under the Employment Rights Order that protect employees from detriment and dismissal where they have a reasonable belief of a serious and imminent danger that they could not reasonably be expected to avert. So, you know, you'll find that under Article 68 and Article 132 of the Employment Rights Order if you're really interested. But the one thing to bear in mind in relation to those provisions is that they are day one rights. So you don't need the typical 1-year service to bring an unfair dismissal claim, for example, if you're dismissed for exercising that sort of health and safety reason. So that's just one thing to be careful about as an employer. And I suppose that reinforces the need to go through your consultation process, complete your health and safety risk assessment, and make sure that you take all reasonable steps that you can take before people actually come back into the workplace. So I suppose the next question that a lot of businesses are turning their minds to is, well, do we actually have a viable business to return to? The impact of this has been so significant that even if there is a viable business, a lot of businesses are recognizing that they're going to have to make changes. So, for example, typically a lot of pay increases would be awarded in April, March, April each year. We've seen a lot of clients who've decided to introduce pay freezes, for example. Other businesses where bonuses would usually be payable in the April pay run, they've either deferred the payment of a bonus or they've simply said that the bonuses aren't going to be payable at all. So I suppose it's just looking at your business to see how you can save money to make sure that you do have a viable business to come back to. More draconian steps that some businesses have taken have been in relation to reducing pay. Some have done it in conjunction with a reduction in working hours, so that employees are still getting the same pay for the hours that they're working. Others have simply introduced a pay cut across the board, for example, a 20% pay cut. Obviously, you need to be very careful in relation to how you go about that process, because effectively you're going to be changing the terms and conditions of your employees, and you can't do that without consulting them and ideally seeking their agreement. We have had some employers who've introduced these changes, and they've had a number of employees who've refused to accept the change. And the question then as an employer is, well, what do you do? There are a number of options, one of which is perhaps to terminate the contract and re-engage, but that's a sort of last resort step. Some employers are simply implementing the changes through payroll, and they're going to wait and see how employees react. Requiring employees to take leave, that's another option. I've talked about the huge accrual of leave, and also the fact that there's been changes to the legislation across the UK to enable employees to carry over their leave into the next 2 leave years. So that's pretty significant. So there could be an enormous build-up of leave, and that's why a lot of employers are going to designate leave periods and require employees to take leave during the quiet period so that they can avoid this huge accrual of leave. And really what you're trying to do is to avoid a redundancy situation, I suppose. And once you've exhausted the furlough scheme, depending on how that pans out, you know, post end of July, you might still need to look at short time working as an option. Some employers have a short time working and layoff clause already in their contracts. And if they have that, then they have the right to place employees in short time working or to lay them off. But if you don't have the contractual right to do that, then you need obviously to consult with your employees and try and seek their agreement. For other employees, it may suit to maybe consider some sort of more flexible patterns of working, particularly those employees who've got, you know, small children or caring responsibilities. But again, employers just need to be very careful in relation to how they broach that with their staff, because obviously, if you're singling out particular employees, you're at risk perhaps of some discrimination claims. So they're really the types of measures that we've seen employers taking so far to try and ensure that they have a viable business to return to, and that they're not having to sort of face the more draconian redundancy route. But if you are a business facing redundancy, I think Anne is now going to take us through, you know, what that process might look like. So I'm going to hand over to Anne.
Thank you, Aisling. I'm going to spend a little bit of time talking about the practical steps around redundancy. As Aisling said, you know, as an employer, you may have looked at all the other various interventions, whether it be reduced working hours, usage of the furlough scheme, changes to your terms and conditions, and you may have exhausted all of those options. And you may have to now consider redundancies. Certainly media reports, etc., would indicate that we're going to be expecting a very significant number of redundancies. And what is important in any redundancy process is that you follow the requirements of the redundancy legislation. So although we are in a situation of a pandemic, we still have to follow the normal employment rules and requirements. And the first thing that you've got to look at in any redundancy situation, is it a genuine redundancy? And, you know, with that, then are you going to be following a fair process? So in terms of genuine redundancy, the sort of things that you'll be looking at is a business closure, a workplace closure, a reduced requirement for employees. So that may mean there's a lesser requirement for the number of employees in particular roles. It may be a change to the roles that employees are actually covering, and you may have to put together a plan in terms of how you're going to reduce your workforce numbers. In terms of what constitutes an unfair redundancy dismissal, really there are a number of things to bear in mind here, where it could then amount to the fact that the dismissal could be unfair. So one of the key things is consultation. Consultation in the current situation we're in with furlough, with lots of people working on a remote basis, that can be quite challenging. So you've got to think around the logistics of that. How can you work with your employees, with your trade unions, with your employee representatives to demonstrate fair consultation? And you will appreciate consultation has to be a two-way process. So you're going to have to think around what sort of interventions are we going to have to put in place to demonstrate that we have consulted in a meaningful way. The obvious, I suppose, platform is this in terms of a digital media type of platform. So, you know, you will then want to look and see, can we engage with their trade unions, with their employee representatives, etc., via means such as a digital platform. In terms of genuine redundancy, you also want to be thinking around that you have a fair selection process, that your pooling is fair, etc., and that you've looked and worked through the various equality proofing mechanisms to make sure that you do have a fair selection process. Key to any redundancy process is planning and communication. And you know, ACAS, quite clearly, this quote from ACAS, the bigger the change and the more people it affects, the more important it is to get communication and consultation right. And that's critical, and that requires a lot of planning up front, so that you can then ensure that you have the proper Q&A documents in place, that you have the proper process documents, that you have template letters, that you have all that documentation to hand, and that's all done in advance of your announcement around redundancies. Actually, now maybe just move on to the next slide. So in terms of consultation, you know, you may be into a situation where it is a collective consultation, and by that what we mean is where you're looking or you're proposing 20 or more employees redundant at one establishment over a period of 90 days or less, in which case you must consult with a recognised independent trade union if you have one, or alternatively then you will have to go through a process of election of employee representatives. And again, you've got to comply very much with the legal requirements around that election process in terms of your employee representatives. And again, you're going to have to be a little bit creative around how you manage that process to ensure that you meet your statutory requirements. Clearly, your consultation, in terms of collective consultation, you must address such things as ways of avoiding the redundancies or reducing the number of employees to be made redundant, mitigating the effects of redundancies, setting out very clearly the reasons for redundancies, and the employer must consult with the appropriate representatives. You will also have to complete your HR1 form and submit that to the department. Now bear in mind, if you're into a 30-day consultation process, that 30 days will only commence from the date that you submit your HR1. So there's a lot of things to bear in mind in terms of managing a collective consultation process. But regardless of whether you're in a collective situation or whether you're in a non-collective situation, so less than 20 redundancies, that obligation to consult with your employees applies regardless. And the consultation must look at the proposals, and they are proposals. So you are coming to the table with proposals, and those proposals will outline the number of redundancies. It will also address such things as what selection matrix that you're going to be using, the pooling, and that all has to be discussed in advance of moving forward with actually affecting the redundancies. In terms of how you manage that process, I suppose our recommendation would be that you need to keep a detailed audit. You need to keep a record of your consultation process. And again, in normal circumstances, what you would do is get employees to sign off the notes of consultation meetings. So you may, again, have to think of different ways of managing that process if you're having to do it on a remote basis. And it may be that you have to accept things like digital signatures, etc. But nonetheless, what is really key in all of this is that you have a detailed process in terms of consultation. When you're looking at minimising risks, if you think about the normal risks that present itself in any redundancy situation, quite often some of those risks could be reduced through good communication and good planning. I suppose we're in a situation now where a number of employers are using the furlough process. So you've got some time in terms of planning, in terms of working through your communication, and make sure that is all done up front. You need to also be looking at ensuring your managers are adequately trained. Delivering redundancy news in any circumstances is difficult, but in the current circumstances, it could be a crushing blow for employees. So think about how you deliver that message, when you deliver it, and make sure your managers have the necessary support in terms of emotional support, but also in terms of documentation. I think that's one of the key learnings that I would like to get across in terms of managing redundancies. It's all around preparation. So, you know, just don't focus on those who will be exiting, but also think about those employees who will remain with the business. And in terms of how do you rebuild those teams, you want to rebuild your businesses. Employers that we are speaking to are thinking about their long-term plans. They're thinking about how they have to diversify their activities. And they're looking also, how can we rebuild the business? So it's also very important to have a strategy in place for your survivors, for those that are going to remain in your employment post the exit of those who may be leaving in terms of redundancy. Your process is key in terms of managing any redundancy process. Clearly, it must be a genuine redundancy, and you can't just have picked someone. Be very careful that you don't leave yourself open to discrimination claims by targeting individuals who just purely by reason of them being on furlough, that they then are automatically made redundant. This potentially could leave you open to an unfair process, and if you or claims in terms of discrimination. Be very mindful that there will be individuals there who are shielding or who have childcare responsibilities, so you have to be very mindful in terms of your redundancy process. You need to think very carefully about your pools. When you're thinking about redundancy pools, you know, there may be types of work which is interchangeable, and you may have to widen your pools. Your selection criteria must be fair, and clearly both pools, selection criteria, all of that must be consulted upon, and it must be relevant to the roles. And again, you need to look at equality proofing your selection criteria. It's very, very important that you use objective and measurable metrics in terms of your selection process. Consider that selection matrix, make sure there is a clear scoring structure, and when you're looking at who is going to be conducting the scoring, make sure that that individual understands and ideally is maybe a manager or a team leader of those particular roles, and is in a position to score the criteria on an objective basis. I suppose you also need to think in terms of other aspects of redundancy. Be mindful that employees are entitled to statutory redundancy pay, or as a minimum, or they may have an entitlement to contractual redundancy pay. If you're offering enhanced redundancy, if you're looking at volunteers, you're not obliged to look at volunteers, but if you are looking at a voluntary redundancy package, then you might want to bear in mind the usage of a compromise agreement or a conciliation agreement through the Labour Relations Agency, which then will safeguard the process. In addition to statutory redundancy pay, employees are also entitled to notice. And again, you know, be mindful in terms of if they have a higher contractual notice, then they will have an entitlement to that. Also, in terms of your process, you know, although we may be in a decreasing or declining economy, you still are required to investigate alternative employment where possible, and to offer that in those such situations where you have suitable alternative employment, then individuals will be entitled to a trial period of 4 weeks. Again, those on family leave and maternity leave, etc., you again need to be very mindful of their situation, and they do need to be given priority. I suppose when we are managing redundancy processes, the sort of key things or factors that we look out for is clearly to follow the redundancy policy, make sure there's a clear business rationale. And when we talk about business rationale, you know, if you take it very back to the very beginning of the process, at the planning stage, you really should be getting those proposals signed off and a record of the proposals, and there's a justification around the rationale for the redundancies. Quite often that might be done at a board level, and what is useful is that a note is taken of that, so again that you have clear audit records throughout the whole process. In terms of the redundancy pool, that may involve discussions with your employee reps, with your trade unions, and it's very important, again, that records of that are kept, and where there are counter proposals put forward, that those are looked at and responded to. Having good process documentation is key. Keeping a good record of questions and answers in terms of what questions have been posed. It's very, very important. Keep an eye in terms of ensuring that you are complying with the redundancy legislation, your duty to inform and consult, and also in terms of your statutory dismissal procedures. Although we are in a pandemic, the normal rules and regulations around employment law are still there and must be followed. So again, make sure that your managers have an understanding of that, and if need be, that they're trained and have some support from your HR department or your legal advisors. Around when you think about informing individuals in terms of that they've been provisionally selected for redundancy, you have to manage that process in a sensitive manner. And what's key is that those individuals, if they have been in a situation where scoring has been applied, that they get that scoring in advance of that provisional redundancy selection meeting. Part of that meeting then will involve discussing the scoring with the manager. And again, this is where it's so important that managers are made accountable for their scoring and that they're able to justify their scoring. Your suitable alternative employment, alternative roles, you still need to explore that and look at that. And I suppose, you know, in terms of providing support for your staff, using your HR department, if you have an employee assistance program, then that may be very valuable at this time and should be rolled out. The whole pandemic, I suppose, has not only has it been a danger to people's physical health, but there are also mental health implications there. And again, you need to be aware of that in a redundancy process. It's difficult in normal circumstances, but it's doubly difficult in the current situation. So, you know, our advice would be around what's really, really critical in this is your planning and your communication and making sure that you have all of that ready in advance of any announcement. I suppose it's maybe an opportunity, Aisling, then to maybe have pick up on some of the questions that we have.
I just saw one there in particular, Anne, on redundancy. You know, whether you have to wait for the furlough scheme to end before commencing a redundancy process, or can you commence it now if, as a business, you're aware that it's needed and the position won't change? And I think that's a question we've seen already. You know, what do you do? On the one hand, the JRS is there to keep people in a job and to give them a source of income. But if, as a business, you know that there's no hope, you know, should you really be availing of the monies at all, or should you just, you know, start the process now?
Yeah,
I think
suppose guidance, Aisling, on that. You know, if you look back to the guidance on the furlough scheme itself, and within the employee guidance, it does clearly state that redundancy could be started during furlough or post furlough. In the employer guidance, then it talks about redundancies at the end of the scheme. So it is a little bit of a grey area, but certainly my view would be, and it's a much debated point with a number of our own clients, my view would be that there's absolutely no reason why redundancy consultation can't start during furlough. I suppose it's more around the question of, as to when those redundancies can be confirmed. You may well have a legal view on that.
No, I would agree with you, but I think maybe a natural cut-off point now might be the 31st of July, because we know at that point that the scheme is going to change, and there's definitely going to be a reduction in relation to the contribution that's going to come from the government. So at that point then, if the employer is saying, you know, there's been some anecdotal talk, is it going to drop to 60 or is it going to drop to 40? So say, for example, the government said, look, we'll pay 40%, and you're a big employer and you say, well, we simply can't afford to continue with this scheme. And, you know, at that point, maybe they might be able to look at things a little bit differently, but we'll probably have a better idea when the guidance is released. At the end of this month. But I would agree with you. I think there's nothing in principle to stop you starting the process. It's just a question of whether, when you actually confirm that determined by reason of redundancy, and probably premature to do it at this stage when the monies are still available, I would think.
Yeah, and you know, I think as well in terms of timing, if as an employer you're looking at 20 or more redundancies, then you're into a 30-day consultation period, and you're going to have to manage that process through. So again, it would be timely to kind of align that with the end of the existing furlough scheme, if you like, at the end of July. If you're 100+ numbers, then you're into a much longer consultation period. You're into a 90-day consultation period. So again, from a planning perspective, I think it's important to look at your numbers and what that consultation period might be, and then I think that will determine, if you like, when you might start consultation. Because the other thing I think that employers need to bear in mind is that sometimes consultation is going to take longer because of the fact that it's having to be done digitally. You're also going to have to set up mechanisms whereby, if you're in a unionised environment, the unions can have access to employees. Normally that's easier done if everyone is on a workplace site, but if you have employees who are furloughed or remote working, it's going to take more time to get those types of platforms set up. So you know, I think you need to build that into your planning, that it may take longer than what it would normally take, because consultation is just going to be a bit of a logistical challenge for everyone. Yeah,
I agree. One of the other questions, can absence records be included as part of the selection criteria? And I think the short answer to that is probably yes. Provided that you're conscious of the, you know, disability discrimination legislation, you know, so I don't know about you, Anne, but you would regularly see, you know, attendance as one of the criteria that you use in the selection matrix. So there's no reason in principle why that can't form part of your process.
And the only thing I would say, I would echo what you've said there, Aisling, that clearly if they're disability related issues, and they need to be borne in mind, or if individuals are off with maternity related absence, and then that needs to all be factored in so that it doesn't become discriminatory in any way. But absence, yes, is certainly something that we would regularly see, as well as other, I suppose, more specific job related criteria in terms of skills. And again, it's about making sure that criteria is you know, it's objective, and that managers then can ascertain how they've conducted the scoring, and they have a justification around it. So whether it's through performance records or you know, skills testing or whatever, so that they're able to justify those scorings. And I think from a HR perspective, a very useful exercise to conduct with managers who've completed scoring is to take them through that process and test them on the scoring, how they've arrived at it. Because once it comes to the provisional redundancy selection meeting, they are going to have to be able to walk through their scoring and provide that justification. And bear in mind, the scoring might move as a result of that, and then that may change the outcome, if you like, of the ranking of those that have been impacted by potential redundancy. So all of that needs to be very carefully worked through from a manager and HR perspective.
Yeah.
I'm looking to see if we other questions here.
There's one about designating holidays for employees that aren't on furlough, and whether you can do that. And again, the answer is yes, provided you give the required notice under the working time legislation, which is twice the length of the leave. So I know that even employers who aren't using the furlough scheme, they may have employees working from home, but things are certainly a lot quieter. So they're really trying to get people to use up their leave now, rather than have this huge accrual problem for when businesses get back up and running.
Yeah. You know, I think again, we're seeing a large number of clients requesting employees to take leave, and obviously giving them appropriate notice of that, and that can be managed through. The reality is people are not going to be going abroad this year, so I think it's around communication, isn't it? And that there's reasonable notice given, and there's a discussion around leave requirements, etc., based on around the operational requirements also. I see a question, Aisling. How do you suggest managing employees who are too scared or anxious to return to work? They do not fall in any of the risk categories, but they are scared, but ultimately the company requires them back to work. And that's a question we're getting lots and lots.
Yeah. I mean, it's tricky, but I think the best starting point is to look at that government guidance that sets out clearly the steps that employers should be focusing on and that they need to take before they bring everybody back into the workplace. Because I think, provided you can show that you've consulted employees about the health and safety issues, you've carried out your risk assessment, you've introduced whatever measures you need to introduce, whether that be, you know, erecting screens, staggering start times, changing where people are seated, you know, not sharing equipment, you know, in an office environment. So provided you've complied with the government guidance and you've done everything in your power, I think it'll be difficult for people, if they don't have an underlying health condition or you know, a very valid reason not to come back, to simply say that they're scared to return, because I don't think they'd be able to satisfy that, you know, serious and imminent risk to health and safety under the Employment Rights Order. You know, if the employer has actually taken all the steps that they've been required to do in accordance with government guidance. But it is a sensitive, tricky issue because people are naturally a bit nervous. But
of course. I think there's also lots of good practice out there. So if you look at some of the manufacturing firms that are back at work or have been in work, there's lots of good practice to look at in terms of how they have done it. And what I would say, communication is key. That employees need to feel reassured, they need to feel confident that the company is taking health and safety requirements seriously, and I think that's only through discussion that you can demonstrate that. And again, you know, if you're in a unionised environment, then it's engaging with your union officials to show them what has been done, and maybe appointing designated almost like marshals in terms of maybe social distancing, what have you, so that people then can see and feel reassured that their workplace is safe. The other thing to bear in mind is that if all the health and safety precautions have been taken and risk assessments have been conducted, etc., it gets to a point where that almost could become, you know, refusal to comply with a reasonable request in terms of returning to work. Now, I think that's your last stop, and you want to engage in discussion before you go there, but ultimately, yes, that can be open to employers, but it's better that it's done through discussion than enforced in that way, if you like, but it still is an option for employers.
Mm-hmm. I think we're getting close to the end, are we, Anne, in terms of time?
Yeah, if there's more questions here. Question, what are the key things to consider when creating pools? I think we've kind of covered that. It's going to be skills based. It's going to be based on the requirements, if you like, for moving forward. So what are the key skills? What's the key experiences? Experience for moving forward. The more objective that criteria can be, the better. You may also then have things like absence, disciplinary records, etc., also built in, but you'll want to think around your weighting of those, each of those criteria, and make sure that it's weighted appropriately. So yeah.
And when you're creating the pool, just to make sure that, you know, you're more likely to be challenged the narrower the pool. So, you know, if you can, you know, widen the pool, then that's probably a better thing to do, because, you know, you're more likely to see tribunal claims where you focus on very narrow pools for selection, where you've got people arguing, well, you know, my job is interchangeable with somebody else's job. So it's just being careful to look at what are people actually doing? You know, are their skills interchangeable within the workplace? Before you make it, you know, a final decision on that.
And I suppose it might also be worth noting at this point that a pool is not applicable in every single case. In some scenarios, you will genuinely have standalone roles, in which case then you deal with those roles on a standalone basis. But there are many cases where you will have a pool and you'll have to devise your selection criteria accordingly. I think that is us in terms of time-wise. There may be, it looks like we have a few more questions, but we can pick up on those separately, and we will get a Q&A document out, and we'll aim to get that out on Monday. So all remains for me to say is thank you very much. Very enjoyable session. Great talking with you, Aisling. And
Thanks.
thank you to the participants.